Sanctions Risk Assessment. Risks in sanctions compliance are potential threats or vulnerabilities that, if ignored or not properly handled, can lead to violations of OFAC's regulations and negatively affect an organization's reputation in business. OFAC recommends that organizations take a risk-based approach when designing or updating an SCP. One of the central tenets of this approach is for organizations to conduct a routine, and if appropriate, ongoing risk assessment to identify potential OFAC issues they are likely to encounter. As described in detail, the results of a risk assessment are integral in informing the SCP's policies, procedures, internal controls, and training to mitigate such risks. While there is no one-size-fits-all risk assessment, the exercise should generally consist of a holistic review of the organization from top to bottom and assess its touch points to the outside world. This process allows the organizations to identify potential areas in which it may, directly or indirectly, engage with OFAC prohibited persons, parties, countries, or regions. The organization conducts or will conduct an OFAC risk assessment in a manner and with a frequency that adequately accounts for the potential risks. Such risks could be posed by its clients and customers, products, services, supply chains, intermediaries, counterparties, transactions, and geographic locations, depending on the nature of the organization. As appropriate, the risk assessment will be updated to account for the root causes of any apparent violations or systemic deficiencies identified by the organization during routine business. For example, an organization's SCP may conduct an assessment of the following: customers, supply chain, intermediaries, and counterparties, the products and services it offers, including how and where such items fit into other financial or commercial products, services, networks, or systems, and the geographic locations of the organization, as well as its customers, supply chain, intermediaries, and counterparties. Risk assessments and sanctions-related due diligence are also important during mergers and acquisitions, particularly in scenarios involving non-U.S. companies or corporations. The organization has developed a methodology to identify, analyze, and address the particular risks it identifies. The risk assessment is updated to account for the conduct and root causes of any apparent sanction and compliance violations identified by the organization during the business, for example, through independent testing or audit.